The oral arguments before the Montana Supreme Court this week will address a question that is important to all Montanans and students as it relates to student records, educational records, and what expectations of privacy do Montanans have when they either enroll in college or their family members enroll in college. In this case, as some people might remember, a book author has requested the educational records of a particular student. State law and federal law prohibit educational institutions and educational agencies from releasing student records without the student's permission. And in this case, the Montana University System, the University of Montana, we do not have any student permission to release the kind of educational records that the book author has requested. And the case is before the Montana Supreme Court because a lower state court said that the records could be released with the names of students redacted or the names of students stricken from the records. Now, a complication is that the United States Department of Education, while not speaking to this particular case, has told us clearly that targeted student records requests, by that I mean records requests where the person making the request identifies a student by name, that those sorts of requests, to fulfill them, do not adequately protect the privacy rights of the involved students because they are by definition then identifiable. So we're before the Supreme Court seeking the court's wisdom and guidance. We believe that all Montanans have a constitutional right to privacy, including privacy in their student records. We take very seriously our obligation to protect our citizens' privacy. And if Montanans want us handing over their student records or their family members' student records without their permission, there had better be a good reason. So that's why we hope the Supreme Court will provide clarity on what we should do. It's impossible to erase or to retract a privacy violation, but it is possible to prevent one. Thus far, we've worked to prevent one under the law as we understand it. But we need to get this right, and we need to have the question answered by the highest court of competent jurisdiction, the Montana Supreme Court, Peter.
Now, real quick, Kevin, I understand that there could be some far-reaching and massive financial repercussions should the Krakauer team win their lawsuit and the Supreme Court says, yes, turn over the records.
There could be, and I want to make clear why we say that. Federal law says that to violate a student's privacy and to release records in violation of the federal law, that among the penalties are the loss of federal funds. So the United States Department of Education, which is the enforcement agency under the federal law, has the right to remove federal funds, such as Pell Grants that students who are in financial need to enroll in college and so forth. The book author has pointed to this fact as not significant or as if it is a bluff. And the book author has done some research and mentions that there are very few, if any, cases where the U.S. Department of Education has removed federal funds. Nevertheless, the law is clear that that is among the penalties that could be enforced. So it's not easy for the university system to just speculate on what the odds would be that a clear penalty in law would be applied. It's almost as if we're being asked to just disregard the law and hope for a small penalty. We believe we have both a fiduciary responsibility, more significant and responsible than that, to the people of Montana, but also the primary responsibility to protect all Montanans' privacy, including any students named by this book author, until we're told by a court of competent jurisdiction that there's good reason to do otherwise.
All right, now let me ask you, and I'm not sure if you would have an answer to this, Kevin, but should the university system come out on the losing end of this, would there be an appeal to a higher court?
Not to my knowledge, Peter. I mean, it is difficult to speculate, but the university system has no worry about doing what the court says we should do. In fact, it's not even the primary. It's not a motive whatsoever of the university systems to withhold documents. It's just clear law that before we can release a student's educational records, we need a student's permission, and we do not have it in this case. So if a court tells us what to do, we are going to take that very seriously and do the right thing. In this particular case, someone could ask, well, but the state district court already issued an order. Well, two things. It issued an order that we are still told would have some problems with it in terms of whether the student's confidentiality could be protected. But also remember that the Helena Judicial District is a Montana judicial district. It's now the law in the Helena Judicial District to actually have a valid court order that includes exercise of appeal rights up through the court of competent jurisdiction, which in this case would be the Montana Supreme Court. So while I can't speculate, we need to read ultimately in the end what the Montana Supreme Court tells us to do, but I will let you know that's what we've been looking for all along.